judgment, there are two judgments in this. One judgment by me, by the Chief Justice, speaking for myself and 7 colleagues, and there is a dissent by Justice Nagarathna. So I'll just read out a few pages. During the course of the hearing, counsel for the petitioners and respondents agreed that the main questions that fall for determination by this court could be reframed in the following terms. A. What is the true nature of royalty determined under Section 9, read with Section 15(1) of the MMDR Act, whether royalty is in the nature of tax? B. What is the scope of entry 50 of List 2 of the 7th Schedule? What is the ambit of the limitations imposable by Parliament in exercise of its legislative powers under entry 54 of List 1? Does Section 9 or any other provision of the MMDR Act contain any limitation with respect to the field in entry 50 of List 2? C. Whether the expression subject to any limitations imposed by Parliament by law relating to mineral development in entry 50 of List 2, pro tanto subjects the entry to entry 54 of List 1, which is a non-taxing general entry. Consequently, is there any departure from the general scheme of distribution of legislative powers as enunciated in MP v. NAGARATHNA? D. What is the scope of entry 49 of List 2 and whether it covers a tax which involves a measure based on the value of the produce of land? Would the constitutional position be any different to a mining land on account of entry 50 of List 2, read with entry 54 of List 1? Whether entry of List 2 is a specific entry in relation to entry 49 of List 2 and would consequently subtract mining land from the scope of entry 49 of List 2. I'll just read out a few of the issues that we have dealt with. First, royalty is not in the nature of tax. The essential characteristics of royalty are that, first, it is a consideration or payment made to the proprietor of minerals, either the government or a private person. Second, it flows from the statutory agreement, a mining lease between the lessor and the lessee. Third, it represents a return for the grant of a privilege to the lessee of removing or consuming the minerals. And fourth, it is generally determined on the basis of the quantity of the minerals removed. The fact that the rates of royalty are prescribed under Section 9 of the MMDR Act does not make it a compulsory exaction by public authority for public purposes, because 1. The compulsion stems from the contractual conditions of the mining lease agreed between the lessor and lessee. 2. The demand is not made by a public authority but the lessor, which can either be the state government or a private party. And 3. The payment is not for public purposes but a consideration paid to the lessor for parting with their exclusive privileges in the minerals. Moreover, the fact that Section 25 allows every recovery of royalty due to the government under the MMDR Act or under the terms of the contract as arrears of land revenue does not make royalty an impost enforceable by law. Section 25 is a standard recovery provision allowing the government to recover any dues payable to it, flowing from statute or the terms of a contract. Pertinently, contractual payments due to the government cannot be deemed to be a tax merely because the statute provides their recovery as arrears. There are major conceptual differences between royalty and a tax. 1. The proprietor charges royalty as a consideration for parting with the right to win minerals, while a tax is an imposition of a sovereign. 2. Royalty is paid in consideration of doing a particular action, that is extracting minerals from the soil, while tax is generally levied with respect to a taxable event determined by law. And 3. Royalty generally flows from the lease deed as compared to tax which is imposed by authority of law. We hold that both royalty and dead rent do not fulfill the characteristics of tax or imposed. Accordingly, we conclude that the observation in India Cement to the effect that royalty is a tax is incorrect. Second issue we have dealt with is interrelationship between entry 50 of List 2 and entry 54 of List 1. Entry 54 of List 1 is a regulatory entry dealing with the regulation of mines and minerals development. The regulatory entries in List 1 and 2 of the 7th Schedule are distinct from taxing entries. Though the power to levy taxes is an incident of sovereignty, it is subject to constitutional limitations. Giving an extended interpretation to general entries to include the power of taxation will grant arbitrary and unconstitutional authority to the Union and the states. Since entry 54 of List 1 is a general entry, it will not include the power of taxation. If Parliament has no legislative competence to tax mineral rights under entry 54 of List 1, can it make use of its residuary powers to gain legislative competence? The answer has to be in the negative. The enumeration of taxes on mineral rights on List 2 is a constitutional entrustment to the states. This court is bound to abide by the constitutional distribution of legislative powers. Entry 50 of List 2 is not an exception to the Sundaramaya principle, which is that taxing entries are enumerated separately from the general entries in List 1 and 2 of the 7th Schedule. The field of taxation cannot be derived from regulatory legislative entries and has to be derived from a specific taxing entry. This principle has now been well entrenched in our constitutional jurisprudence. A legislature has incidental and subsidiary powers with respect to a legislative entry. However, the power to tax is neither incidental nor subsidiary to the power to legislate on a particular matter in the nature of a regulatory entry. Entry 50 of List 2 is subordinated only to the extent of any limitations that may be imposed by Parliament by law relating to mineral development. Unless Parliament imposes a limitation, the plenary power of the state legislature to levy taxes on mineral rights is unaffected. Parliament can impose limitations under Entry 50 of List 2 by means of statutory provisions. There is no specific provision in the MMDR Act which imposes limitations on the power of the states to tax mineral rights. The scheme of the MMDR Act cannot, by a process of stretched construction, be read to limit the taxing powers of the states under Entry 50 of List 2. Since royalty payable under Section 9 is not a tax on mineral rights, any limitation on the enhancement of the rates of royalty is not the imposition of a tax under Entry 50 of List 2. Section 9 does not expressly impose any limitations on the power of the state to tax mineral rights. Section 9(3) limits the power of the central government to enhance royalty more than once in 3 years. This limitation does not govern taxes on mineral rights. As held in Jindal Stainless Steel, the Constitution understands the expression limitations as restrictions, conditions, or principles. However, does the expression any limitations include the power to prohibit states from taxing mineral rights? We are of the opinion that the answer must be in the affirmative. Under Entry 50 of List 2, the Constitution specifically uses the phrase any limitations. The framers of the Constitution intended to empower Parliament to impose all and every possible limitations on the taxing power of the state in the interest of mineral development, which may include even a prohibition. Then the third issue is scope of Entry 49 of List 2. The expression lands includes lands of every description. A land may be put to use for growing tea leaves or extracting minerals. But what Entry 49 of List 2 contemplates is the levy of a tax on land as a unit, irrespective of the use to which it is put. Therefore, the state legislature is competent, while designing the levy under Entry 49 of List 2, to tax lands which comprise of mines and quarries. In other words, mineral-bearing land also falls within the description of lands under Entry 49 of List 2. We do not agree with the respondent's submission that the mineral rights are transferred from the state to the mining lessee only upon the extraction of minerals. Once the lease deed is signed, the interest in the minerals is transferred from the state government, in the case the minerals vest in the state government, to the lessee. The interest of the lessee in the minerals continues until the determination of the lease deed. It is only upon the exercise of mineral rights by the lessee, that is, removal or consumption of minerals, that the lessee is required to pay royalty. Thus, the transfer of interest in the minerals is distinct from the exercise of the mineral rights. In view of the above discussion, it is clear that minerals are decoupled from the land only upon the exercise of mineral rights by the lessee. After the decision in Goodrick, in particular, it is now well established that the income or yield of land can be adopted as a measure of tax. The assessment of tax on land depends upon the actual or potential productivity of the land sought to be taxed. The productivity of mineral-bearing land can be measured on the basis of the minerals produced. The yield from mineral-bearing land is nothing but the quantity of mineral produced. Royalty is per se not the yield from a mineral-bearing land, but the yield mineral produced is the important factor in the determination of the rate of royalty. Moreover, royalty can be considered as an income if it is paid to a private landowner. In case the minerals are vested in the state, the royalty is paid to the state government and hence assumes the form of non-tax revenues. Therefore, royalty is relatable to the yield of the mineral-bearing land as well as the income in the case the minerals vest in a private person. Both the entries, Entry 49 and 50 of List 2, deal with distinct subject matters. Both the entries operate in different fields without any overlap. The fact that mineral value or mineral produce is used as a measure under Entry 50 of List 2 does not preclude the legislature from using the same measure for taxing mineral-bearing land under Entry 49 of List 2. The doctrine of general alia specialibus non derogant has no application in the instant case because Entries 49 and 50 of List 2 operate in different fields. Though Parliament can limit the taxing field entrusted to the state under Entry 50 of List 2 through a law relating to mineral development, the limitation operates on the field of taxing mineral rights. Such a limitation cannot operate on Entry 49 of List 2 because there is no specific stipulation under the Constitution to that effect. Conclusions. We answer the questions formulated in the reference in terms of the following conclusions. A. A royalty is not a tax. Royalty is a contractual consideration paid by the mining lessee to the lessor for enjoyment of mineral rights. The liability to pay royalty arises out of the contractual conditions of the mining lease. The payments made to the government cannot be deemed to be a tax merely because the statute provides for their recovery as arrears. B. Entry 50 of List 2 does not constitute an exception to the position of law laid down in MPV Sundaramaiah. The legislative power to tax mineral rights vests in the state legislatures. Parliament does not have legislative competence to tax mineral rights under Entry 54 of List 1, it being a general entry. Since the power to tax mineral rights is enumerated in Entry 50 of List 2, Parliament cannot use its residuary powers with respect to that subject matter. C. Entry 50 of List 2 envisages that Parliament can impose any limitations on the legislative field created by that entry under a law relating to mineral development. The MMDR Act as it stands has not imposed any limitations as envisaged in Entry 50 of List 2. D. The scope of the expression any limitations under Entry 50 of List 2 is wide enough to include the imposition of restrictions, conditions, principles, as well as a prohibition. E. The state legislatures have legislative competence under Article 246, read with Entry 49 of List 2, to tax land which comprise of mines and quarries. Mineral-bearing land falls within the description of lands under Entry 49 of List 2. F. The yield of mineral-bearing land in terms of the quantity of mineral produced or the royalty can be used as a measure to tax the land under Entry 49 of List 2. The decision in Goodrick is clarified to this extent. G. Entries 49 and 50 of List 2 deal with distinct subject matters and operate in different fields. Mineral value or mineral produce can be used as a measure to impose a tax on lands under Entry 49 of List 2. H. The limitations imposed by Parliament in a law relating to mineral development with respect to Entry 50 of List 2 do not operate on Entry 49 of List 2 because there is no specific stipulation under the Constitution to that effect. And I. The decisions in India Cement, Orissa Cement, Federation of Mining Associations of Rajasthan, Mahalakshmi Fabric Mills, Saurashtra Cement, Mahanadi Coalfields, and P. Kannadasan are overruled to the extent of the observations made in the present case.
I have perused the comprehensive opinion authored by Honorable the Chief Justice of India Dr. Dhananjaya Y. Chandrachud on the questions referred to this 9-judge bench. I respectfully dissent with the said opinion and express my reasons therefore. Sum and substance of all the questions referred to this bench could be crystallized to the short point for consideration, namely whether royalty as envisaged under Section 9 of the Mines and Minerals Development and Regulation Act 1957, for short MMDR Act 1957, is a tax or an exaction. At this stage itself, it must be made clear that the concept of royalty is being considered from the perspective of Section 9 of the MMDR Act and not from any other context. My short answer is that viewed from the statutory framework of the MMDR Act 1957, passed by the Parliament on the strength of Entry 54, List 1 of the 7th Schedule of the Constitution of India, and having regard to Section 2 of the said Act, royalty is in the nature of a tax or an exaction. Further, Section 9 of the MMDR Act is a limitation within the meaning of Entry 50, List 2 of the 7th Schedule, and the states have no legislative competence to levy any other tax, impost, or fee on the exercise of mineral rights. Entry 49, List 2 is also not applicable to mineral-bearing lands. Therefore, India Cement Limited has been correctly decided by a 7-judge bench of this court, and the majority judgment in State of West Bengal versus Kesoram Industries Limited is incorrect and therefore ought to be overruled. I propose to discuss in detail the reasons for the aforesaid view. I have considered in this case the interpretation of the entries, and some portions I may be permitted to read. If payment of royalty, which is a consideration for exercise of mineral rights, is expressly covered under Section 9 of the Act, can the same be a basis for any other exaction by a state, either by imposing another tax or cess based on royalty or by imposing any other tax on mineral-bearing land? This is a question which has fallen for consideration in several cases before this court, as well as before several high courts. As noted above, royalty is a consideration imposed by a lessor on a lessee of a mining lease for the grant of mining lease, which in sum and substance is a requisite consideration for exercise of a mineral right. Royalty and dead rent, as envisaged under the scheme of Section 9 and 9A of the Act, have been imposed by the Parliament in the interest of mineral development in the country. The fact that under Sections 9 and 9A, payment of royalty and dead rent, as respectively envisaged as per the conditions stated in the said sections, would clearly indicate that having regard to development of any particular mineral, the rate of royalty has been fixed under the 2nd Schedule in the MMDR Act. Therefore, it is in the interest of mineral development that a lessor is bound to collect royalty and dead rent from a lessee in terms of what is envisaged under the said provisions. The payment of royalty is to the lessor, which is the state, which executes the lease deed in terms of Form K of the Mineral Concession Rules 1960. Thus, having regard to the statutory scheme envisaged under Sections 9 and 9A of the Act, any exercise of mineral right by a lessee is subject to the payment of royalty to the state government. The exaction of royalty is therefore statutory in nature. Then I have proceeded to consider the 4 aspects in Govindasaran and Gangasaran and how those 4 aspects will clearly fit into this. The 4 components are: first, that Section 9 deals with the payment of royalty in respect of mineral removed or consumed. 2, it is by a holder of mining lease who is obliged to pay the royalty. 3, at the rate specified in the 2nd Schedule to MMDR Act. And 4, a percentage of the average sale price on ad valorem basis. Although Section 9 of the Act is not worded in the manner a charging section in a taxation statute is normally worded, nevertheless, its import must be understood in the sense of it being a taxation provision. For the aforesaid reasons, I hold that royalty is in the nature of a tax or an exaction. Then I have considered the various judgments of this court on this aspect. I'll just refer to them. Hingir Rampur, M.A. Talak, Bajnath Kedia, HRS Murthy, India Cement, Laddu Mall, Lakshmi Narayan Mining Co., Orissa Cement, Mahalakshmi Fabric Mills, Mahanati Coalfields, Saurashtra Cement, Goodrick, Kesoram, Kannadasan. Then I have said that Goodrick need not be distinguished and have given my reasons as to how that judgment does not apply in the present case. As far as Kesoram is concerned, I have given 8 reasons, including the imagined typographical error, which are not correct, and therefore I say that Kesoram should be overruled. Then coming to Kannadasan, the judgment in Kannadasan is clearly established the fact that Parliament has supremacy over the regulation of mines and development of minerals in entry 54 list 1, read with section 2 and the other provisions of the Act as entry 23 list 2 is also subject to entry 54 list 1. That levying of a uniform impost in the form of royalty and debt rent imposed under sections 9 and 9A throughout the length and breadth of the country, so far as a particular mineral is concerned, without letting any state to impose any other levy over and above royalty, is in the interest of mineral development. That sections 9 and 9A are an embargo and a limitation on the power of the state to impose any tax on exercise of mineral rights. This is because royalty is paid on exercise of mineral rights. It is a statutory exaction under the Act and is compulsory for every holder of a mining lease to pay royalty to the state government, which executes the lease deed in the status of a lessor. Payment of royalty being compulsory by the holder of a mining lease, it makes it a tax at the rate of royalty is fixed by the central government as per section 9 of the Act and as notified in the second schedule. Thus, royalty being a tax would be collected as arrears of land revenue in the event of non-payment. Such being the construction and interpretation of the provisions of the Act in light of the entries in the list, royalty as a compulsory exaction has met all the parameters of a tax, and hence the provisions regarding collection of royalty under the Act and the rules made thereunder act as a limitation under entry 50 list 2. Hence, the states are denuded of their power to impose a cess or any other levy on royalty or define it as a land revenue, which could be imposed by the states under entry 49 list 2. Such state levies on royalty is against the interest of mineral development in the country, and therefore the state levies on the basis of royalty was struck down by this court and certain high courts. The Validation Act also established the fact that Parliament, by passing such an act, did so in the interest of mineral development in the country and to save the states from losing the revenue collected through the incompetent levies prior to 4/4/1991. Therefore, the states were not required to refund the illegal levies collected by them and continued to collect the same till 4/4/1991. The sustaining of the Validation Act by this court is also significant. Thus, as a result of the Validation Act, the decades-old controversy between states' attempts to levy taxes on royalty and the High Courts and this court striking down the same by holding that it was the Parliament only which could do so by a law, brought down the curtains on the said controversy till its revival in Kesoram. Justice Jeevan Reddy, speaking for the bench in Kannadasan, cleared any lurking doubt We also discussed Tata Iron and Steel and how, despite that judgment, Kannadasan and Tata Iron and Steel consistently hold that royalty is a tax, and how the Parliament came to the rescue of the states to see that the incompetent levies were sort of legalized. In view of the aforesaid judicial and legislative history, can this court once again confer power on the states to levy taxes on the exercise of mineral rights, in addition to royalty by way of a cess or a surcharge on cess, on independently on the basis of royalty as a measure for imposing such taxes? The majority judgment in Kesoram has attempted to do that. This is by holding that royalty imposed under Section 9 is not a tax, and therefore the states can levy taxes on mineral rights either under entry 50 or entry 49 list 2. Thus, the legal quagmire has not ended but continue. In my view, the majority judgment of Kesoram is liable to be overruled for holding that royalty is not a tax for the following reasons. I have given 8 reasons for the same. I need not go through it now. In view of the aforesaid discussion, I differ from the judgment of Honorable the Chief Justice of India and hold that India Cement, Orissa Cement, Mahalakshmi Fabric Mills, Saurashtra Cement, Mahanadi Coalfields have been correctly decided and therefore are binding precedent and cannot be overruled. The second aspect of this case, which also requires consideration, is with regard to interplay of entries 49 and 50 list 2 in the context of mineral bearing lands. Again, I have given 8 reasons for saying that entry 49 list 2 does not apply and that it is only entry 50 list 2 which has to be considered in light of entry 54 list 1. I need not go into all that in detail. In view of the aforesaid discussion, I also observe that mineral value or mineral produce cannot be used as a measure to tax mineral bearing land under entry 49 list 2. Also, the word lands under entry 49 list 2 cannot include mineral bearing lands as well. That this would amount to, within inverted commas, double taxation, so to say, imposed by 2 different legislatures, one by the state legislature on the mineral bearing land under entry 49 list 2, and again for conducting a mining operation, which is for exercise of a mineral right under section 9 of the Central Act, which is a parliamentary law and which has to be paid to the state government. This is impermissible, having regard to the constitutional intent and scheme of entries in the list. Thus, royalty cannot also be a measure to impose tax on mineral bearing land. Hence, the state legislature using royalty on mineral produce as a measure to impose a cess under entry 49 list 2 on mineral bearing land would indeed overlap entry 50 list 2. What is the effect of overruling India Cement? A survey of cases on the aspect as to whether royalty is a tax or not would reveal that Hingi Rampur, M.A. Talak, Vaijnath Kedia, India Cement, and the 2 judgments of the Patna High Court and Mysore High Court have clearly held that royalty is a tax coming within the scope and ambit of Article 366(28) of the Constitution. There are other judgments which have followed India Cement. This is having regard to the interpretation of the entries, namely entry 50 list 2 in light of entry 54 list 1 and the declaration made in section 2 of the Act and the scheme of the provisions of the said Act. On the other hand, HRS Murthy and Kesoram have held otherwise. What is significant is between India Cement and the cases that have followed the said dictum and Kesoram is the judgment of this court in Kannadasan, which makes a watershed in the entire controversy and in fact has put a closure to the same. The circumstances which led to the Parliament enacting the Validation Act was to validate all the incompetent levies imposed in the form of cesses and surcharge on cesses, license fee, etc. on royalty, which has been set aside by this court. Parliament was constrained to enact the Validation Act having regard to entry 54 list 2 and section 2 of the MMDR Act. This significant aspect has not been appreciated by the majority in Kesoram. Instead, the judgment in Kesoram proceeded on an imagined typographical error in paragraph 34 of India Cement without appreciating the reasoning therein for holding that royalty is a tax. I have dissected that paragraph 34 and what it exactly means. Apart from questioning the verdict of a larger bench on the premise that there was a typographical error, the majority in Kesoram lost sight of the implication and the adverse impact that this view would have on mineral development in the country. If royalty is not held to be a tax and the same being covered under the provisions of the Act, it would imply that despite entry 54 and the declaration made in section 2 of the Act and section 9 and 9A and other provisions thereof, taxes on mineral rights be imposed by the states over and above payment of royalty on a holder of a mining lease. This would also mean that the limitation that the Parliament has made by law on the taxing power of a state explicitly stated in entry 50 would be given a go-by. This would further imply that despite such a parliamentary limitation, the states could pass laws imposing taxes, cesses, surcharges, etc. on the basis of royalty, which is in addition to payment of royalty. Further, such levies could also be imposed under Entry 49 List 2, thereby making Entry 50 List 2 redundant, which is not acceptable. As a sequitur, this would result in mineral development in the country in an uneven and haphazard manner, and increase competition between the states and engage them into what has been termed by the scholar Louis Dillon in a race to the bottom in a nationally sensitive market. There would be unhealthy competition between the states to derive additional revenue, and consequently the steep, uncoordinated and uneven increase in cost of minerals would result in the purchasers of such minerals coughing up huge monies, or even worse, would subject the national market being exploited for arbitrage. The steep increase in prices of minerals would result in a hike in prices of all industrial and other products dependent on minerals, which may result in certain entities or even non-extracting states resorting to importing minerals from which would hamper foreign exchange reserves of the country. This would lead to a breakdown of the federal system envisaged under the Constitution in the context of mineral development and exercise of mineral rights. It could also lead to a slump in mining activity in states which have mineral deposits, owing to huge levies that have to be met by holders of mining licenses. Further, another impact of this would be an unhealthy competition to obtain mining leases in states which have the mineral deposits and who do not wish to impose any other levy apart from royalty. It is therefore necessary to realize why the framers of the Constitution took a clue from the Government of India Act 1935 in order to distribute the legislative powers between the Union and the state list insofar as regulation of mines and minerals is concerned. At this juncture, I must also observe that the overruling of the judgment in India Cement would mean that all the judgments which are akin to the ratio of India Cement, whether prior to or subsequent thereto, stand overruled, irrespective of whether they are judgments of the High Court or this court. Consequently, all states would again start levying taxes on minerals under Entry 49 List 2 and thereby bypass Entry List 2 so as to not be bound by any limitation that the Parliament has imposed by law on the power of the states to levy taxes on mineral rights. The circle would come around when Parliament would have to again step in to bring about a uniformity in the prices of minerals and in the interest of mineral development so as to curb the states from imposing levies, taxes, etc. on mineral rights. Why should that happen again? There would then be legal uncertainty, which would cause adverse economic consequences, including on mineral development in India. For the above reasons also, the majority judgment in Kesaram is not good law and ought to be overruled to the extent that it holds that royalty is not a tax. Then I have discussed about federalism in India, and I have quoted Jawaharlal Nehru, who was the chairman of the Union Powers Committee of the Constituent Assembly, who was of the view, quote, "It would be injurious to the interest of the country to provide for a weak central authority which would be incapable of ensuring peace, of coordinating vital matters of common concern, and of speaking effectively for the whole country in the international sphere," unquote. Then I have spoken about the Sarkaria Commission report on center-state relations, and where there is a quotation from that report that is specifically with regard to mineral rights and with regard to simultaneous operation. And I will read that portion only. Simultaneous operation side by side, two inconsistent laws, each of equal validity, will be an absurdity. The rule of federal supremacy is a technique to avoid such absurdity, resolve conflicts, and ensure harmony between principle, therefore, is indispensable for the successful functioning of any federal or quasi-federal constitution. It is indeed the kingpin of the federal system. Draw it out, the entire system falls to pieces. If the principles of union supremacy are excluded from Articles 246 and 254, it is not difficult to imagine its deleterious results. There will be every possibility of our two-tier political system being stultified by intestine strife, legal chaos, and confusion caused by a host of conflicting laws, much to the bewilderment of the common citizen. The federal principle of unity in diversity will be very much a casualty. The argument that states should have legislative paramountcy over the union is basically unsound. It involves a negation of the elementary truth that the whole is greater than the part. Quotations from the report of Justice Sarkaria. Aforesaid discussion, I find that the learned Attorney General is right in contending that the MMDR Act contemplates all manner of levies, charges, imposts, or demands that could be provided for having a nexus with mineral rights. Therefore, the Act itself has to be construed as a limitation on the power of the states to demand or impose levies to the extent to which is stated in the Act. Although entry 50 is list 2 is a taxing entry, it will be subject to the limitations enacted by the Parliament by law under entry 54 list 1. The answer to the question raised by learned Solicitor General whether the states can impose levies under entry 50 list 2 over and above the amount of royalty received by them under the Act is in the negative. The submission that entry 50 is sui generis because it is the only legislative entry which limits the taxing power of the state legislature by reference to a general law is a correct submission made by Sri Harish Salve, Learned Senior Counsel. Therefore, the expression mineral development found in entry 50 list 2 has to be traced to the entire architecture of the Act, which serves as a limitation of the taxing power of the state legislature under entry 50 list 2. To read it otherwise would lead to destruction of the federal balance, as rightly contended by Sri Salve. Further, tax on mineral right would also include royalty as envisaged under Section 9 and the other sections of the Act, which is in the nature of a sovereign exaction, and every holder of a mining lease is bound to pay royalty in terms of Section 9, read with second schedule to the said Act. In that sense, royalty is a tax on mineral rights, which has to be compulsorily paid by the holder of a mining license, irrespective of the owner of the mineral-bearing land is concerned. Also, the Act and the rules made thereunder is a complete code on the regulation of mineral development, and royalty paid by a holder of a mining license is nothing but a tax on mineral rights. The state legislature cannot, on the basis of royalty paid, levy any other taxes or surcharge. The states can only levy tax on sale of minerals as per entry 54, list 2, as it then stood, which is not a tax on mineral rights, as rightly contended by Sri Datar, Learned Senior Counsel. Moreover, entry 50 list 2 is a recognition of parliamentary superiority via imposition of a limitation, as rightly argued by Dr. Singhvi, Learned Senior Counsel. Consequently, the contention of Learned Senior Counsel Sri Rakesh Dwivedi for the appellant states, through the effect that value of minerals could be used as a measure to tax mineral-bearing land under entry 49, list 2, cannot be accepted. It is also not right to contend that the Parliament has only fixed the amount of royalty payable under Section 9, which cannot be a limitation on taxing power of the state legislature under entry 50 list 2. Moreover, the expression any limitation used in entry 50 list 2 can be construed to mean even a prohibition apart from a restriction. There I agree with my Lord the Chief Justice. And then accordingly, for the 4 issues, I have given my answers in a tabular form. And then I have given my conclusions arrived at. I need not once again read that after this lengthy reading. And they are A to I. Then the 11 questions are again answered in particular. 1 to 5. In the result, in my view, the judgments in India Cement, Orissa Cement, Mahalakshmi Fabric Mills, Saurashtra Cement, and Mahanadi Coalfields are correct and therefore are binding precedent and cannot be overruled. On the other hand, the majority judgment in Kesoram is overruled to the extent it holds that royalty is not a tax. The registry is directed to place these matters before Honorable the Chief Justice of India for directions on listing the matters before the appropriate bench. I must place on record my sincere appreciation to the learned Attorney General, learned Solicitor General and their teams, learned Senior Counsel appearing for the respective parties, learned Instructing Counsel and learned counsel for the respective parties for their valuable assistance to this bench. Thank you.
Lord, Lordship may clarify the judgment prospective. Your Lordship is now taking a view royalties, not a tax. Now, my Lord, all this time, like in cement cases in Madras, all are following the India cement rule. Now, if a Lordship says it's not a tax, what happens to the past period? What happens to,
There would
to
be
clarify that?
So this.
Economy of every state.
Lord, there's a theory of second actor.
Kesharam is operating in Bengal, my Lord, so it has to go back to Kesharam's point of time at least.
Because, Lord, in India Cements, para 35, they say,
Lord, it would be exchange of money, center, states. It would create, my Lord, complications.
No,
But
that-
kindly
yes,
hold it to
para
the
35
prospect.
of India Cement says,
Especially since the 9-judge bench is overruling, Malan, that
Yes.
7 judges.
Lord, para 35 of India Cement says it will be prospective.
Say that this will be prospective. What is, have you reflected in it?
No, but,
That
with
would
great
be
respect, my
complete
Lord, it means, my Lord, that the enactments which are under challenge, from that date of time, my Lord, they remain invalid in part and then become.
No, no.
Lord, if the Lordship says this, if the Lordship is not a tax, then we have to pass validation act. All the states have to pass validation acts.
Let's
Pending assessments are there, appeals are there.
May I say, irrespective,
There are amounts of,
Yes.
huge amount of recovery, my Lord, sir, with great respects.
Lord, may I also?
What is it? What is-
Manoj, your-
Irrespective of subject matter.
Today's Thursday. We will.
No, my
We
lord.
will keep it on just this aspect. We'll keep it on Tuesday. We'll hear you for 10 minutes.
Your Lordship may also note, Your Lordship's judgment in 2019, 12 SCC 623. Lordship said that if a matter is referred to a larger bench, till then the earlier judgments continue to be binding.
Yes.
So until 22nd of July or 25th
In
of
any
July.
case, when 9 judges overrule, 7 judges. Malan.
The-
9 judges overrule
Then is
7.
day for the after notice matters come up, there's plus a miscellaneous board on Tuesday. We'll keep it on Wednesday,
Wednesday.
just for 10 minutes in the morning. That we
Very
can, they were agreeable, it was different, but we shouldn't.
Very good.
There is
resolve
one
this
state
amount of-
versus, my Lord,
And
yes,
not-
there would be.
Not one state, there's.
No, I am right now, I am because of-
Revenues you have been withholding, enjoying that revenue for a very long time. So
Anyway,
now
if it is not to be agreed, my Lord, we'll argue.
Wednesday,
Yes, yes.
We'll argue on Wednesday.
Except
Lord, Your Lordship has to
Jharkhand
find out what happens
and
if it
Odisha,
is retrospective,
where
what
the
happens
act
if it
was
is
struck
prospective.
down. In most of the other states, the high courts held the acts to be valid.
And pursuant to
We have a-
Kesharam, West Bengal is realizing.
And your
this
lordships
now.
only stayed the impugned judgment to the extent that 50% of the dues are paid by the SSEs. So it's not something which, so therefore.
All right, if you can.
No, we will assist your lordships.
Reflect
What will be
just
the
a
effect?
Small little note on it, just 2 pages or so. So when we take a call on this, we can have considered view from both sides.
What can be considered probably is, my lord, to release the burden on the petitioners to some extent by removing the burden of penal interest or the
No,
quantum
that
of
is not
interest.
there.
But the tax amount has to come. my lord.
irrespective of subject matter, when a 9-judge bench overrules a 7-judge bench, your lordship
It's-
always normally.
Yes, my Lord, more a question of law, my Lord,
Irrespective of
whether
subject-
prospective or retrospective.
No.
Not penalty or etc. My Lord, we are not
Of impact.
concerned with penalty.
It's a question of impact, not law.
This can be seen by the
And
different.
the Lordship has overruled 7
Question
judgments.
of impact, not law.
Yes,
When your lordship overrules so many judgments, lordship always makes it prospective.
so those judgments have operated. That's the.
Lord, what will happen is that the matter
All
goes
right, we'll
back.
keep it on Wednesday only on this. We'll hear you for 10 minutes each. I don't think that will take us more than half an hour. And then we'll take a
We'll give on-
considered follow.
Please,
If it's going to go
Okay.
back to the division benches and the high courts, then what will they follow? This again a problem.
So, my lords, 10 minutes on their side will mean 60 minutes for us. my lord. No, lighter win.
So Wednesday morning, we'll assemble.
Obliged.
Great for us.
oblige.
Reserve this.
Yeah, while sister was dictating the judgment, she's indicated 8 reasons.
Yes.
And it struck me then that it is a judgment of 8:1. She actually had 7 reasons. Then she thought that there is one more. There are only 7 days in a week. So she found out 7 reasons on those 7 days. A lot of people have the impression that judges have a lot of holidays. So one more day out of 7 days. One more day. She worked one more day, although we have 7 days, and she brought out 8 reasons. Compliments.
Grateful.
Grateful to Lord.
Yeah. Oh.